role tends to involve law reform projects and major policy issues. This work, of course, has been a large focus of the department's work and the government's work since the inception of the Commission.
Thank you. I invite you to speak to your submission, Ms Vickers.
First of all, I'd like to say thank you for the invitation to attend, and the Tasmanian Government has been pleased to participate in this project. We acknowledge the work of the Royal Commission in collating a large body of evidence and work, and we hope to be able to contribute to the work in a constructive way and demonstrate leadership in moving forward and considering some of these complex public policy issues. The focus of my statement, or the government statement today, is really on civil law reform and redress, and it follows from previous submissions we've made to issues papers and the submission that has been recently published. Tasmania believes civil law reform and redress are key components in providing justice to survivors of child sex abuse. The Royal Commission's work and our own work has highlighted many barriers to victims who may wish to pursue civil claims. And I don't proceed to go over the details of all those things, but we see limitation, financial means, emotional resources, the adversarial and protracted nature of civil law, evidentiary burdens, finding an entity, the relationship between entities and individuals within those organisations often confound victims in being able to pursue claims. I wanted today just to focus on 2 points that we've made in our submissions in relation to limitation periods and statutory duties. As the Commission probably know, governments over time have responded to calls for reform in relation to limitations. Many here and on the Commission would recall the work based on His Honour David Ip, the report of the law into the law of negligence. Most of that work was brought about by an insurance crisis and also later by victims of dust diseases and latent diseases. In considering that work, Tasmania changed its law and introduced new provisions in relation to limitations. We have provisions where we have 3 years from the date of discoverability, and there's also long stop provisions and provisions in relation to children or minors under a disability. I really only raise that today to say that at the time these provisions were being considered through the work of His Honour David Ip, at that point the Tasmanian Government considered it inappropriate to restrict reforms just to a class of victims, and at the time many would recall there was a lot of pressure in relation to asbestosis and dust diseases, but our government had recognised that there were other types of latent injuries that existed in the community and they ought to be included, and such as post-traumatic stress disorder injuries that were being suffered by survivors of sexual abuse, and that is clearly on the record in Hansard. So we accept that this work now is sort of moving reform for our government in terms of limitations. We don't believe that we've got the law perfectly right, and obviously as we move forward in this process we're conscious that we may need to make further reforms to address particular victims or people wishing to pursue civil law actions. We currently watch with interest some of the developments. We know that Victoria have tabled some law reform, and we're interested to see how they will proceed over time. The second point I wanted to make is that Tasmania is not in favour of absolute liability. We consider it more appropriate and effective to apply a duty that makes institutions liable for child sex abuse committed by members unless the institution is able to prove that it took all reasonable precautions to prevent that abuse. We prefer this approach as it has the potential to promote good governance and risk mitigation into the future. And we've also seen this approach being used in areas such as workers' compensation. Absolute or strict liability, while seemingly may make it easier for people to sue, it doesn't provide incentives for organisations to change practice and remove risk within their business models. We think we're happy to examine these areas of civil law reform, and we believe that they may go some way to addressing barriers that many survivors face in taking civil litigation. But we do acknowledge there are significant other issues that potential plaintiffs face, such as evidentiary burdens, and that, as I alluded to earlier. This probably leads me to the reason why Tasmania favours a redress scheme to civil action. We think that redress can offer more timely, efficient and less stressful avenue for many survivors to access justice. It's also fairer and can provide equal access. And as you probably are aware from our submission, we have expressed some concern that we don't want to limit any reform that we make just to victims or survivors of institutionalised child sex abuse. We're concerned that a lot of child sex abuse can occur within other settings such as families, and that many people in institutions also suffer different types of abuse such as physical or emotional abuse. So in responding to policy questions posed by the work of the Commission, our position is that we prefer a scheme that can benefit all classes of victims. We also think, because many of these victims have been survivors of horrific acts, which I think our society would view as criminal, and to that end it shaped our thinking that our position is, in the absence of any commitment by the Commonwealth to establish a national scheme, our preferred position is that we build on our existing victims of crime compensation scheme. As you already know from some of our submissions, we have a scheme. We think there are significant benefits to adopting this approach, but building on the existing framework. It would provide a consistent framework for survivors of child sexual abuse to access redress. It's more equitable. We wouldn't seek to distinguish between types of child sex abuse. We could address past and abuse ongoing issues into the future. It also characterises the behaviour of perpetrators as criminal, and that may be important for some survivors of these acts. It also, for government, it's about building on current administrative infrastructure, and that can provide us with some benefits. It may be easier to access for victims, as we've heard over the last few days, that there's often very complicated arrangements within non-government organisations and their structures, so it would provide an open door for victims. Such a model, of course, would require further work and cooperation from non-government organisations and entities, and we'd be seeking cooperation in terms of funding and re-engagement and apology processes. I believe we'd also need some legislative framework for appropriate information sharing between non-government organisations and our own, so that assessment of claims, re-engagement and those sorts of things could occur. We also accept that we may need to consider the current burden of proof provisions within our Victims of Crime Compensation Act. It's currently at the balance of probabilities, but we're aware, and we, as you know, have run a redress scheme in the past where plausibility was considered more appropriate in those sorts of matters. Non-government cooperation is vitally important for us for two reasons. We need to develop a sustainable model, and we need to ensure that institutions can contribute to the costs of running that. And we also recognise that many survivors want responsibility for the things that happen to them attributed to those organisations or people that were directly responsible. So we would like to work with the non-government sector and church groups and various other bodies to ensure that they would be able to participate in any apology, explanation or re-engagement with people, as we've seen through your work and other research that these are key principles of a redress scheme. Finally, I'd probably like to say that while government may lead change through law reform and statute changes, partnership and collaboration are vital to achieving justice for all victims, and we'd be seeking to work with other non-government entities to achieve that.
Thank you, Ms Vickers.
Ms Vickers, thank you. Those thoughts are very helpful. And I just ask you, I assume that in proffering modification to your Victims of Crime scheme and anticipating that the institutions would contribute or participate in some way, you don't see any practical impediments. I know there'd be a lot of negotiations and legislative drafting and so on, but you don't ultimately see any practical impediments to that happening.
It's probably early to say, but in any sort of area of law reform, I mean, at the end of the day, an Act of Parliament is the law.
Yeah.
But we know that we can't achieve law change by just pushing ahead with legislative reform without engaging with people. So it is really early days, but we would be looking at recovery provisions and those sorts of things. So in my experience in doing law reform, generally we'd be building on the work of the Commission, discussion paper out, receiving submissions. It's been important for us to participate in this process because we can get a feel for where some institutions are heading and what they think they may be liable for. But yeah, there could be practical problems in terms of people coughing up their contribution to any scheme. But ultimately...
Well, that leads me to the next question. Let's assume there are problems. Perhaps the institution has no money or has ceased to exist. Would it be contemplated that the government would nevertheless fund the scheme to provide appropriate redress for people who've come from those institutions?
I think the government doesn't accept that it's absolutely the funder of last resort, but clearly it may be in some situations, particularly if we're characterising some of the behaviours that are perpetrated as essentially criminal conduct. That fits within a framework of a criminal injuries compensation model.
You know, of course, that the numbers that we proffered in the discussion paper are more than you might have contemplated under your schemes previously.
Certainly.
Is that a problem?
I think that would be a matter that government would have to consider. So we've run a scheme which had various caps. We currently have caps and limits on the Victims of Crime Compensation Scheme. Those matters would all need to be reviewed in the course of any changes to our legislation and model.
The complementary issue is it's clear to all of the commissioners from what we've learnt that many people who have suffered from abuse have a need for counselling, perhaps lifelong or at various stages of their life. Now, your scheme that you've had in place has gone some way along that journey, but would it be recognised by government in your state that there is a need to address, for some people, a lifelong need?
Well, currently, under the Victims of Crime Compensation Scheme that we run, a person may receive a sum of money, but they also have money set aside for counselling and health and wellbeing type services. In that, if the money's exhausted, it's not common, but it's not uncommon for people to reapply again for further source of money. So I think as a policy position, the government recognises that the victims of some crimes at present do need ongoing counselling.
When you say apply, I assume some are treated favourably.
I believe they are. So I think there's a recognition that some people need additional supports, and I think the work and matters that are set out in the paper do highlight those things, and we accept that that will be the case.
We're also interested in your state's views about this question of the duty of care and how it should be framed. Why wouldn't absolute liability impose or bring a response from an institution that it would do everything it could to avoid there being a problem?
It's an interesting question, Your Honour, but I think that we've probably based some of our thinking on workers' compensation type models and other and motor accidents insurance models. I mean, on the flip side, it may, be an impetus for organisations to do everything, but on the other side, there's always, well, it doesn't matter anyway because whatever we do, we're liable. That we factor in that sort of approach and I don't know whether that's fair, and I think these are initial thoughts that we've presented to the Commission.
It's interesting. I don't know what your legislative structure in Tasmania is, but in in some parts of Australia, the states have imposed absolute criminal liability for offences committed by corporations. Pollution is one, industrial safety is another. Anyway, we welcome
and there are projects around directors' liability that are seeking to wind some of that back. So, you know, we're mindful that, you know, through the COAG process, that some of those matters are being re-examined, and certain governments are more keen to reduce regulatory burden and
Ms Vickers, the Tasmanian government had an abuse in state care scheme.
yes, we did.
That ran for about a decade.
Yes.
And that covered children who'd been abused in entirely state-run institutions?
No, it covered, well, not entirely state-run institutions. It recognised that the state did outsource some of those functions, so that basically the eligibility was set around whether a child was a ward of state. And ward of state's is sort of the old terminology. Now we would talk about children on care orders, but so it was essentially for children that were under some state guardianship or ward order.
And was the decision taken to include non-government organisations who were funded to provide that care because the state took responsibility because of the child protection arrangement?
Yeah, primarily, yes.
How did you come about the 10 years period over which you accepted claims?
I'm not sure whether I can easily answer that. So it was run in 4 rounds, and I think it was more about being reactive to what was happening in the community, that people might have felt that they hadn't been able to participate, or there was another group that were coming through, because the cut-off date, as you're probably aware, was fairly arbitrary. So, you know, essentially it ran for that time to try and capture as many people as possible.
So is it the case that as the numbers started to dwindle, you got closer to a cut-off date?
And you'd be aware too that the first 3 rounds were for higher cap, and then the last round, for economic reasons and other reasons, had been lowered slightly, by half actually. So,
did you receive some criticism from the community for halving the cap for those who came later?
I couldn't answer that. The scheme was predominantly run through the Department of Health and Human Services, but so I probably wouldn't seek to answer that.
Thank you.
I have a question. Just a brief one to you, please, Ms Vickers. The victims of crime compensation tribunals throughout Australia, where there haven't been specific redress mechanisms for abuse cases of the type we're considering, have been regarded as the default redress scheme. Do you and your government consider that for future cases of abuse in this class, that the Victims of Crime Compensation Tribunal will be the primary redress mechanism?
Yes, we would, and that would be, it just would mitigate against having to create another specialist tribunal to assess sort of certain claims. So we'd like to build on what we currently have for both the past and the future.
So you would expect the Royal Commission to be concentrating on how those schemes might be adjusted to ensure redress is adequate?
Yes, yes.
All right, thank you.
Yes, thank you, Ms Vickers. And again, like others, can I thank you for your contribution and your government's contribution. It's been most thoughtful, and we're grateful.